Google has been accused of secretly tracking people's use of the Safari internet browser. Judges at the Court of Appeal have ruled today that British consumers can sue Google in this country for the anxiety and distress it may have caused. Campaign Group accused the company of monitoring their online browsing so that people can be targeted with personalised advertising. Well, joining us from our Southampton newsroom is Marc, who's one of the original claimants who brought the case against Google. Marc, welcome to BBC News. Can you tell us, first of all, how you became involved with this case? What prompted you to take this action?
Yeah, it was a few years ago, actually. I was involved in a privacy campaign group online, and I heard that they were looking to bring a case on this matter relating to the similar thing that happened in the US, and were looking for applicants, so I decided to get involved.
Why do you believe this is a breach of the law?
I suppose really it's about Google's attitude to the law. I mean, they already admitted in the US court that they'd done what they with regards to the tracking, that they'd carried on with the opt-out even when people had said they wanted to opt out. So what they actually did is not in question, but it was the fact that we wanted to bring the case in the UK to address kind of the attitude that Google seemed to think they were above the law ultimately.
This judgment means you can proceed with action in this country, but there's nothing in the judgment, is there, to suggest that you will win this?
No, not that. That's true. I mean, ultimately, this judgment was affirming the judgment that was made last year. This was Google's appeal against the judgment for us to bring it. The actual case, as yet, nothing's been heard. None of the arguments have been brought to the table. It was Google really appealing that they didn't think that the UK was the appropriate place to bring the judgment, bring the case in the first place. That we should have to go to the US when Google are clearly a UK-based company as much as they are in the US. They have UK customers, so we didn't think that was right.
So what's the next step for you?
Well, the question at the moment is whether Google are going to decide to try and take this decision to the Supreme Court if they don't agree with today's judgment. Ultimately, today's judgment was quite firm, so we're quite confident that hopefully that won't happen. But if they do go to the Supreme Court, then it'll be heard there, and then hopefully the same decision will be read out, at which point we'll go to court with the actual case.
Is for you the ultimate objective then to get companies who are using this kind of software to be clear with consumers that if they wish to opt out of this kind of activity, they can do so and their preference will be honoured? Yes,
I think that's really it. It's about the attitude towards privacy. I mean, Google seems to see users as a commercial object, and really we need to address that. If a user decides to opt out of something for their own personal privacy, then they should have that right to do so, and that needs to be respected. And that's clearly just not Google's attitude at the moment. And the same with other companies. Ultimately, they need to respect users' privacy and their wishes.
Marc Bradshaw, thanks very much for being with us from Southampton tonight, and congratulations on this, if you like, stage one victory for you and your campaign.
Thanks very much. Yes, it's great. Cheers.